Subject is regulatory framework and legal issues in business. BL223. But first, before we continue with the lecture, my credit to the following researchers: Sara Cagata, Lynn Francis Garque, Miss De La Cruz, Miss Trelio, Miss Hamen, and Miss Pac. The judicial foreclosure or extrajudicial foreclosure. Number 4, what are the kinds of redemption? Number 5, what are the exceptions of binding effects of acts on third party? Number 6, state the doctrine of mortgage in good faith. Number 7, explain the doctrine of ostensible agency. Number 8, what is the obligation of the mortgagee if it's a bank or financing institution? Number 9, what will happen if the agent wishes to sell property on behalf of the principal and there is no special power of attorney? And lastly, what payment shall proceeds of the sale go? Okay. Let us go to the answer, the question and answer. Give at least 2 effects of if authority exceeded. 1, it becomes an enforceable contract. And number 2, it's apparent authority. Number 2, what is due diligence of third party? Answer: a person dealing with an agent must also exercise the diligence of a good father of authority of a family. The third party cannot claim protection if the agent failed to exercise due diligence and it turned out that the agent exceeded this authority. Question number 3. Define judicial foreclosure and extrajudicial foreclosure. Answer: judicial foreclosure, a mortgage may be foreclosed judicially by bringing an action for that purpose in the regional trial court of the province or city where the real property or any part thereof lies. While extrajudicial foreclosure is a mortgage may be foreclosed extrajudicially where there is inserted in a contract a clause giving the mortgagee the power upon default of the debtor to foreclose the mortgage by an judicial sale of the mortgage property. Number 4, what are the 2 kinds of redemption? 1, equity of redemption, and 2, right of redemption. Number 5, what are the exceptions of binding effects of acts on third party? Answer: the exceptions are: 1, if he expressly binds himself; 2, if the agent exceeds the limit of his authority without giving such party sufficient notice of his powers; or number 3, if he contracts in his own name even if in fact he has authority. Number 6, state the doctrine of mortgage in good faith. Answer: reliance in good faith on certificate of title of mortgagor, title in the name of mortgagor, not of rightful owner; duty of mortgage to look beyond certificate of title; greater care and diligence required of mortgage bank. 7, explain the doctrine of ostensible agency. Answer: anybody who makes it appear that the agency is authorized is bound by the act of the agent. However, apparent authority is determined only by the acts of the principal and not by the acts of the agent. Number 8, what is the obligation of the mortgagee if it's a bank or financing institution? Answer: the general rule stated that the purchaser of a mortgage of a land is not required to look further than what appears on the face of the torrent certificate of title does not apply. Number 9, what will happen if the agent wishes to sell the property on behalf of the principal and there is no special power of attorney? Answer: there will be no contract of sale because it would result in a void contract. Number 10, what payments are the proceeds of the sale go? What payments shall the proceeds of the sale go? Answer: A, cost of sale; B, the amount due the mortgage; C, claims of persons holding subsequent mortgages in the order of their priority; D. The balance, if any, shall be paid to the mortgagor. Okay, let us discuss nature and binding effect on third person. Okay. Binding effect of acts on third party. The general rule is that the agent who acts as such is not personally liable to the party with whom he contracts. That's the general rule. What are the exceptions? 1. If he properly binds himself or expressly binds himself, meaning the principal. 2. If the agent exceeds the limits of his authority without giving such party sufficient notice of his powers, or if he contracts in his own name, even if he in fact has the authority. What else? Effect if authority exceeded. If the agent contracts in the name of the principal, exceeding the scope of his authority, and the principal does not ratify the contract, it becomes an enforceable contract. The contract entered into if the agent exceeded his authority is unenforceable as far as the principal is concerned, exception if the principal ratified such contract. Or when void even as to the agent, the contract is void if 1. The contract was entered into by the agent who exceeded his authority, and the party with whom the agent contracted is aware of the limits of the powers granted by the principal. In this case, however, the agent is liable if he undertook to secure the principal's ratification. Apparent authority. The principal may be bound by an apparent authority given to the agent. The principal is liable if he clothes the agent with authority in the eyes of the third persons. Doctrine of apparent authority is also known as the holding out theory or the doctrine of ostensible agency, meaning anybody who makes it appear that the agent is authorized is bound by the acts of the agent. However, apparent authority is determined only by the acts of the principal and not by the acts of the agent. Due diligence of the third party. A person dealing with an agent must also exercise the diligence of a good father of the family. The third party cannot claim protection if the agent failed to exercise due diligence and it turned out that the agent exceeded his authority. Now, the third party chargeable. A person who deals with the agent is put upon inquiry and must discover upon his peril the authority of the agent. If he does not make such inquiry, he is chargeable with the knowledge of the agent's authority, and his ignorance of that authority will not be an excuse. Number 2, production of power of attorney. A third person with whom the agent wishes to contract on behalf of the principal may require the presentation of the power of attorney or the instructions as regards the agency. Private or secret orders and instructions of the principal do not prejudice third persons who have relied upon the power of attorney or instructions shown upon them. Now, rights and obligations of mortgagor and mortgagee. Let us discuss the doctrine of mortgage in good faith. Now, reliance in good faith on certificate of title of mortgagor. A mortgagee has a right to rely in good faith on the certificate of title of the mortgagor of the property given as security, even in the absence of any sign that might arouse suspicion. He has no obligation to undertake further investigation. Hence, even if the mortgagor is not the rightful owner of or does not have a valid title to the mortgage property, the mortgagee in good faith is nonetheless entitled to protection. This is called the doctrine of mortgagee in good faith. Title in the name of mortgagor, not a rightful owner. This doctrine presupposes, however, that the mortgagor who is not the rightful owner of the property has already succeeded in obtaining a torrent's title over the property in his name, and that after obtaining the said title, he succeeds in mortgaging the property to another who relies on what appears to be the said title. The mortgagee for value protected by the law is one who purchases a title land by virtue of a deed executed by the registered owner. The duty of mortgagee to look beyond certificate of title. As a general rule, where there is nothing in the certificate of title to indicate any cloud or vice in the ownership in the property or any encumbrance thereon, the purchaser is not required to explore further what the torrent's title upon its face indicates in quest for any hidden defect or inchoate right that may subsequently defeat this right thereto. This rule, however, admits of an exception. And where the mortgagee has knowledge of the defects or lack of the title, the vendor of the mortgagee does not directly deal with the registered owner or the real property, or that he was aware of the sufficient facts to induce a reasonably prudent man to inquire into the status of the property in question. Greater care and diligence required of mortgagee bank. When the purchaser of mortgagee is a bank or financing institution that is required to observe a higher standard of diligence, its business is impressed with the public interest. The general rule that the purchase of mortgagee of land is not required to look further than what appears in the face of torrent's title does not apply. Article 2126. The mortgage directly and immediately subjects the property upon which it is imposed, whoever the possessor may be, to the fulfillment of the obligation for whose security it was. Now, effects of the mortgage. 1. It creates a real right. A mortgage creates what is called real right, which is enforceable against the whole world. It follows the property wherever it goes, therefore. If the mortgagor sells the mortgage property, the property remains subject to the fulfillment of the obligation secured by it, but the mortgage must be registered. See Article 2125. Or if not registered, the buyer must know of its existence. What else? Effect of mortgage. It creates merely an encumbrance. Mortgage, however, is merely an encumbrance upon the property and does not extinguish the title of the debtor, who does not lose his principal attribute as owner, that is the right to dispose. Macolo versus Beloso and Cernab, 46 Philippines 1. Indeed, the Philippine considers void any stipulation forbidding the owner from alienating a mortgage immovable. Article 2130. 2127. The mortgage extends to the natural accessions to the improvements, growing fruits, and the rents or income not yet received when the obligation becomes due, and to the amount of the indemnity granted or owing to the proprietor from the insurers of the property mortgage, or in virtue of expropriation of public use, with the declaration, amplification, and limitations established by law, whether the estate remains in the possession of the mortgagor or it passes into the hands of a third person. Extent of mortgage. A mortgage constituted on immovable property is not limited to the property itself, but also extends to all its accessions. Now, effect of mortgage. Mortgage constituted in immovable property is not limited to the property itself, but also extends to all accessions, improvements, growing fruits, and rents or income. Kindly see Article 2102. As well as the proceeds of insurance should the property be destroyed, or the expropriation value of the property should it be expropriated. Therefore, all objects permanently attached to a mortgaged land or building, although they may have been placed there after the execution of mortgage, are also included. Case in point, Bishop versus Pomar, 12 Philippines 690, Manahan versus Cruz, 61 Skra 137. And to exclude them, it is necessary that there be an express stipulation to the effect. Let's go to Article 2128. Mortgage credit may be alienated or assigned to a third person in whole or in part with the formalities required by... What is this? Let's talk about alienation or assignment of mortgage credit. The mortgage credit, the right of the mortgagee, is a real right, meaning by delivery, and directly and immediately subject the mortgage property to the fulfillment of a principal obligation. Such a real right may be alienated or assigned to a third person in whole or in part by the mortgagee who is the owner of said right. The sale or assignment is valid even if it is not registered. Registration, therefore, is necessary only to affect third persons. Article 2129. The creditor may claim for a third person in possession of the mortgage property the payment of the part of the credit secured by the property which said third person possesses in the terms and with the formalities which the law establishes. Right of creditor against transferred or mortgage property. The fact that the mortgagor has transferred the mortgage property to a third person does not relieve him from his obligations to pay the debt to the mortgage creditor in the absence of novation. The mortgage credit being a real right which follows the property, the creditor may demand from any possessor the payment only on the part of the credit secured by said property. It is necessary, however, that prior demand for payment must have been made on the debtor and the latter failed to pay. Case in point, Bank of Philippine Islands versus Concepcion and Hijos Incorporated, 53 Philippines 906. Article 2130. Stipulation forbidding the owner from alienating the immovable mortgage shall be void. Stipulation forbidding alienation of mortgage property. The law considers void any from stipulation forbidding the owner from alienating the mortgage property. Such a prohibition would be contrary to the public good inasmuch as the transmission of property should not be unduly impeded. This is coming from the report of the Code Commission, page 158. However, if the mortgagor alienates property, the transference is bound to respect the encumbrance because, being a real right, the property remains subject to the fulfillment of the obligation for whose guarantee it was constituted, found under Article 2126. The form, Article 2131. The form, extent, and consequences of a mortgage, both as to its constitution, modification, extinguishment, and as to other matters not included in this chapter, shall be governed by the provisions of the mortgage law and land registration law. Now, let us go to the rules governing mortgage. As to the matters not included in Chapter 3 of the Civil Code, the provision of the Spanish Mortgage Law of 1889, Land Registration Law or Republic Act number 496 as amended, and the revised Administrative Code, more particularly Section 194 as amended by Act number 334, govern the form, extent, and consequences of a mortgage, and also its constitution, modification, and extinguishment. Kindly see Philippine Bank of Commerce versus De Vera, 6 CRA 1026. Foreclosure of mortgage. Foreclosure is the remedy available to the mortgage by which he subjects the mortgage property to the satisfaction of the obligation to secure which the mortgage was given. 41 CJ 830. Through the sale of the property at public auction and the application of the proceeds thereof to the payment of his claim. It denotes procedure adopted by the mortgagee to terminate the rights of the mortgagor on the property and includes the sale itself. Case in point, DBP versus Saragossa, GR number L23493, decided on August 23, 1978. Let us go to the kinds of foreclosure. Foreclosure may be affected either judicially or extrajudicially. Let us talk judicial foreclosure. 1. A mortgage may be foreclosed judicially by bringing an action to the purpose for that purpose in the regional trial court of the province or city where the real property or any part thereof lies. See Section 2 Rules of Court. If there be a balance due to the mortgage after applying the proceeds of the sale ordered by the court, the mortgagee is entitled to recover the deficiency. See Section 6 IB. And if disembodied in a judgment, it is referred to as deficiency the judgment. Where a third person is the mortgager, he is not liable for any deficiency in the absence of a contrary stipulation. The action for the recovery of such deficiency must be directed against the debtor. The proceeds of the sale shall be applied to the payment of the A. Cost of the sale, B. Amount due of the mortgage, C. Claims of persons holding subsequent mortgages in the order of the priority, and D. Balance, if any, shall be paid to the mortgager. Section 4 IB. Let us go to extrajudicial foreclosure. What is this? It is a mortgage may be foreclosed extrajudicially where there is inserted in the contract a clause giving the mortgagee the power upon default of the debtor to foreclose the mortgage by an extrajudicial sale of the mortgage property. See Section 1 Act number 3155 as amended by Republic Act 4148. What do you mean by redemption or redemption of foreclosed property? Redemption may be defined as a transaction by which the mortgagor owner of mortgage property reacquires or buys back the property within a certain period and for a certain amount after his default or after the foreclosure sale of the property for the satisfaction of the mortgage debt. Now, what are the kinds of redemption? They are, number 1, equity redemption. What is equity redemption? Equity redemption is the right of the mortgagor to redeem the mortgage property after his default in the performance of the conditions of the mortgage but before the sale of the mortgage property. In judicial foreclosure, the mortgagor may exercise his equity of redemption before but not after the sale is confirmed by the court. Found in Section 3, Rule 68, Rules of Court. Case in point, Raimundo versus Sonico, 25 Philippines 365, and it has talked about right of redemption. Number 2, right of redemption is the right of the mortgagor to redeem the mortgage property within a certain period after it was sold for the satisfaction of the mortgage debt. In all cases of extrajudicial sale, the mortgagor may redeem the property at any time within the term of 1 year from and after the date of the registration of the sale. Kindly see Section 16, Act number 3135. Case in point, Reyes versus Tolentino, 42 SCRA 365. In judicial foreclosure, the general rule is that the mortgagor cannot exercise his right of redemption after the sale is confirmed. With that, we conclude our lecture and we say thank you. Maraming salamat po.